Welcome to another episode of Patently Clear with Graham Archer. So, in this episode, we're going to be talking about the basics of intellectual property or IP because, let's be honest, a lot of people think they know the term but not really understand what falls under that umbrella. So, Graham, could you kind of break it down for us?
Sure. Intellectual property is basically a group of legal rights that protect creations of the mind. And there are four main types. There are patents, they protect how things work. Registered designs, they protect how things look. Trademarks, they protect brands. And then copyright, that's for creative works of art, literature, music, and even things like computer programs. All of these are protected by law, which allows people to earn recognition or financial benefit from their inventions or creations.
Okay, so it's like owning a house, but instead of bricks and mortar, you own creations of the mind.
Exactly. And just like a house, you can buy, you can sell, you can rent, license, mortgage, or even give away your IP rights. Some of these rights are free, but most need to be registered. And here's a key point. For many of those rights, they're territorial. That means they have to be registered in each country where you want protection.
Okay. So can we go through them one at a time? So let's look at patents first.
Sure. So patents protect how things work, not how they look. They can cover products and also methods like manufacturing processes or ways of using a product, even computer programs. They last for up to 20 years, and because they're registered rights, you have to file them in each country where you want protection.
Okay, and you can't just patent anything, is that right?
Yeah, that's right. Your idea has to be new and involve an inventive step. You can't get a patent for a tiny, insignificant tweak to something that already exists. But the bar isn't so high that small improvements are excluded. In fact, most patents are small but beneficial improvements rather than big moonshot inventions.
Okay, so it's not all kind of rocket science.
Not at all. In the UK, about 5,000 to 6,000 patents are granted each year, and last year over 100,000 European patents were granted. It's about contributing something, big or small, to the stock of human knowledge in your field. And here's something that's worth knowing. In the UK, patents can also save you money on tax. If your product is covered by a UK patent, you can claim patent box tax relief on the profits from sales worldwide, as long as they're coming through a UK a UK company that's paying corporation tax.
Okay. So can we now move on to registered designs?
Yeah. Registered designs protect how something looks, its appearance, not its function. In the UK and Europe, they last for up to 25 years, although in other countries it's often shorter, 15 in many places and just 10 in China. They're territorial, like patents, and the products must be new, but instead of an inventive step, it has to have individual character, meaning that it looks different enough from existing designs.
Okay, and there's not really an exam for these, is there?
No, exactly. In the UK and Europe, and many other jurisdictions, registered designs aren't formally examined before they go to grant. That means that they're much quicker and cheaper to obtain than patents.
So there's probably a downside.
Well, yes. You won't know for sure if it's valid until you try and enforce it. There are also unregistered design rights in some countries, but the duration and rules vary. For example, unregistered rights last between 5 and 10 years in the UK, but only 3 years in Europe.
Okay. So now on to trademarks. So these protect brands, is that right?
Yes. Trademarks are there so customers know the true source of a product or service. They can last indefinitely, as long as they're being used and you pay the renewal fees. The oldest UK trademark involving the Bass Beer Red Triangle was registered in 1876 and is still in force today. Trademarks are preferably registered rights, but unlike patents and designs, you can register them after you've started using them in a country. That means you can expand your protection as your business grows. although it's smart to check the trademark registers before launching a brand in a new country, so you don't find yourself being blocked by an existing registration.
Okay, and two companies can have the same trademark if they're in different industries, is that right?
They can, yes. So take Apple, for example. The Beatles' Apple Music and Apple Computers. It wasn't an issue at first because they were in very different sectors, but when Apple Computers started selling music, things got messy and they had to make a deal.
Okay. And then last but not least is copyright.
Copyright protects works like literature, art, music, recording, and computer programs. It's free and automatic. It exists the moment your work is recorded in some form, whether it's written down, typed, or saved digitally. One key thing is being able to prove when you created it. Traditionally, people would mail themselves a copy by registered post and keep it sealed as evidence. For software, copyright protects the actual code, not the idea behind it. So if I see a program and want to create its functionality from scratch without copying the code, I can do that without infringing copyright. But if that functionality is patented, then I'd still be risking infringement. So with software, copyright stops people from copying the code, but patents stop them from copying the idea.
Oh, I see. That's great. Thanks, Graham.